The question that I'm posing is, can I limit pets in my rental to just dogs and cats? And so I'll be talking about what the law says, what leases say, and what landlords can do in situations that have to do with pets. And if you have a pet question or really any question related to landlord-tenant law, I welcome you to ask. Join the chat. Let us know what questions you've got. But we can go ahead and get started. We're talking all about whether or not a landlord can limit pets on their rental to just dogs and cats. Let's talk first of all about the kinds of animals that are excluded from this conversation. I mean, in most jurisdictions, you simply cannot have an exotic animal. You can't have a pet bear. You can't have a tiger. You probably can't have a camel in most residential property. So it should be pretty explicitly clear, if it's not implied, that tenants are not allowed to have exotic animals. Certainly, if you allow pets, absolutely limit whatever your jurisdiction restricts as an exotic animal. And again, different jurisdictions are going to have different kinds of animals on that list. But if you just use the general term exotic animal and you require your tenant to follow the laws of the jurisdiction where you're in, you kind of have a catch-all. So there is generally no waiver for this in a given jurisdiction. You simply cannot have certain pets. And so absolutely no exotic animals. The question, however, poses, if you could limit the kinds of animals that are on the property to just cats and dogs. And the good news is when it comes to pets, you as a landlord can essentially put whatever limit you want up to and including a complete exclusion to every single kind of pet known to man. You are by no means required to allow a tenant to absolutely allow the tenant to have a pet. And so if your preference is, look, I'm fine with dogs, I'm fine with cats, but I got a thing with snakes or spiders, hamsters stink, I don't want them in the house, so no rodents, but I'm fine with cats and dogs, you can actually put that limit. And if the tenant has a cat, has a dog, and then has a baby goat, that's a violation, right? And so it's not a matter of, well, any four-footed creature, and any quadruped is fine. No, you can say exclusively, if you're going to have a pet, you're limited to cats and dogs. In fact, you can limit the size of the animal. If you say, for example, I'm fine with all cats because they're at a good size, but no dogs over 50 pounds. There's nothing wrong with you limiting pets in any way that you like. You can absolutely put these restrictions. And if you have these preferences, you should utilize them. However, unless you're subject to an exception from the Fair Housing Act, and there are certain instances where landlords are or could claim an exclusion to the Fair Housing Act, unless you're subject to that exclusion, you can't limit people and their assistance animals. And so, no, you can't say, well, I'll accept an assistance cat or an assistance dog, but nothing beyond that. At that point, it's no longer a pet. And so because it's not a pet and because there's protections under the Fair Housing Act, you're unable to make these same exclusions when it comes to, again, an animal's an animal, except when that animal is not a pet. And so no exotic pets, that's absolute. But if you've got between a pet and an assistance animal, you can put all sorts of restrictions on pets, but you can't put those same restrictions on assistance animals. Now we're going to get to what is reasonable and whether you can reasonably expect certain acts by an owner of an assistance animal, someone who uses an assistance animal, For example, you can require that they keep their assistant's dog on a leash. Perfectly reasonable. In fact, most jurisdictions require that as a matter of law. And so, but in terms of the kind of animal or the size of the breed, as long as it is reasonable for the tenant to have that animal, it is not reasonable for you to restrict it or the size or the breed based on solely on your preference. Now, in certain jurisdictions, and this is true about, for example, C&I dogs. C&I dogs are limited to dogs, and technically speaking, it could also be a C&I miniature horse. But other than that, you don't get a C&I cat or a C&I llama or a C&I falcon. Those things just don't exist in the law. So in that way, if someone's trying to pass off some other kind of animal as a C&I, armadillo, that's not gonna fly. And so now remember, and we've had this talk numerous times on this channel. There are certain ways where you can confirm or verify the validity of someone's claim that they have an assistance animal. We're not going to go into that today, except in the questions that pertain specifically to that. But for today's talk, yes, generally speaking, when it comes to pets, you can put restrictions on pets. When it comes to service animals, you generally cannot put restrictions on the size, breed, or type of animal. But definitely if you're dealing with an exotic animal, again, check your jurisdiction. Anything that's deemed exotic and is prohibited can absolutely be excluded. Even if some doctor says, oh no, that's their assistant's crocodile. If that's not allowed in your jurisdiction, you can exclude it from the property. So that's, in a nutshell, some of that having to do with pets and assistance animals. The law can get kind of confusing. And so if you've come up with a question and would like to ask it again, add that question to the chat. I'll be happy to get to it. Otherwise, I've got a set of questions here. I see that Makis Kais has asked, if your home rules require all animals, cats and dogs, to be neutered or spayed, can this rule apply to all animals, including an ESA? So the question is whether or not this is a reasonable request, and that's going to come down to the court in your local jurisdiction. Does local jurisdiction require that all animals be spayed or neutered? I doubt it. And so if you're requiring some medical procedure of animals, I don't know that even if they are pets, when they're pets, you can say, yes, you can have a pet if it is spay or neutered, but for ESA or any kind of assistance animal, you very likely cannot. Again, that might be deemed an unreasonable restriction on the individual that would violate the Fair Housing Act. So pets, yes. Emotional support animals, probably not. Now, stuff like this is going to come up in the law, and eventually local jurisdictions are going to come up with rules that are better than what we have now. Unfortunately, right now it's still kind of up in the air because this area of the law is so new. So I hope that helps. My general feeling is requiring that that an animal undergo a certain medical procedure based on your preference alone. Again, unless you can connect the need for this, to a very specific, unless you have a very specific basis to require this, I just don't think you can pull it off as a reasonable requirement. Okay, first question from the list. Janice Sanchez asks, well, first is, thanks for the opportunity to submit questions, and she submitted 3. So Ms. Sanchez, here we go. Number 1, how does accepting dogs affect my landlord insurance policy? Do I need something from their renter's insurance stating they are covering the dog? Well, I'm not familiar with your insurance policy, so I couldn't tell you whether you allowing dogs on the premises in any way violates the provisions of your insurance policy or serves as an exclusion to coverage. So the best way to resolve this is A, to read your policy, or B, to discuss the matter specifically with your insurance provider to make sure that you're covered, even if you allow your tenants to have dogs. Your second question in that first question is, do I need something from the renter's insurance? Now, I always suggest that if you're going to allow pets onto the property, and again, this is pets, not assistance animals, but if you're going to allow pets, that you require the tenant to have some degree of liability insurance. And this is specifically for the likelihood, the possibility that the dog might be involved in a biting incident or in some way cause harm either to the property or to a third party. You want that additional layer of protection. And so you can require that anyone with a pet get insurance. Whether you can require that same thing of a person with an assistance animal, again, that's up in the air, whether or not it is a reasonable matter, because you might have someone with a legitimate medical condition who is prevented from renting based on this restriction, which again, a court might deem is unreasonable for them. So there's that. But yes, absolutely. If you're going to allow pets, I would suggest that any landlord who allows a pet also requires their tenant to secure liability insurance that covers dog bites. Are landlords allowed to request vaccination records for their dogs? And so, yes, again, this is one of those things where for any pets, you can make as a restriction or part of the agreement that their dogs be vaccinated and that they provide evidence of this prior to move-in. So absolutely, you can require this, and it is encouraged. And then the third part of the question, dog A passes away. Does dog B need a new non-refundable pet deposit? Well, I tell landlords all the time, there's no such thing as a non-refundable deposit. Let's make sure we take that out of our heads. That doesn't exist. If it is a deposit, it is always refundable. If it is a fee, then it goes to a specific cost. Let me give you an example. Every time in between tenants, you hire Joe's Carpet Restoration Company. And Joe's Carpet Restoration Company comes in, you pay him $400, and Joe goes to town on that carpet and makes it awesome. Awesome. Smells great, looks great, nice and healthy, real comfortable carpet. You love Joe's. And you tell your tenant, look, I allow all my tenants to have pets. And so by having pets, you agree that your pet's going to do some damage to the carpet. And so in order to restore this, I'm going to charge you a $400 cleaning fee. And so you can either A, hire Joe yourself and show me proof that you hired Joe, or B, pay this fee that I'll use after you're gone and apply it again to Joe to clean it, to restore the carpet to where it was the day you moved in. So that is a fee that you specifically to restore the carpet in your home to the condition that it was when the tenant took occupancy at the beginning of the lease. But a deposit would only kick in if that pet did harm to the property. And so let's say that pet never touched the carpet somehow. They kept the pet restricted to the tile floor in the kitchen. Maybe there's tile in the living room, and the pet never made it upstairs, never touched a stitch of carpet, not once. I don't know that that you could find any way to justify, assuming that pet did no damage whatsoever and was clean, it didn't stink up the house, didn't pee anywhere inside the house. that's not a refundable. Again, that's a perfectly refundable pet deposit if you can't justify utilizing those fees to some damage caused by the pet. So number one, I don't believe in referring to anything as a non-refundable pet deposit. In this case, the question is, because it's fully refundable, does the deposit transfer from A to B? Well, that's gonna depend on what your restrictions are. If dog A is a 10-pound little doggy and dog B is an 80-pound big doggy, they might not match, and that might go beyond your other restrictions. And so because of that, you might require an additional amount of deposit, or you may restrict this and say, look, you're not allowed to bring dog B in. And then once you vacate, we can discuss whether or not any amount of this deposit is refundable. But we're not going to do that in the middle of the deposit, even if dog A died and you can't bring on dog B. So be aware of that. Maintain your restrictions throughout, but understand that there's no such thing as a non-refundable deposit. If it's a deposit, it's a current payment for potential future costs. And if you're going to keep any amount of that deposit, it better go to something very specific. All right. Question number 2, Dylan Thrasher asks, how can I handle frivolous, reasonable accommodation requests when they're used as a tactic to prevent eviction? Well, Dylan, I'm not sure that I have enough. You use contradictory terms. I wonder if you mean frivolous, quote, reasonable accommodation requests. The truth is, if a tenant proves that they made a reasonable accommodation request that you deem is frivolous, that doesn't change the fact that it was, again, deemed valid by the court. And so you really have to ask yourself, do I know the difference between a frivolous claim and a valid claim for some reasonable accommodation? Before you jump the gun, make sure you've gotten some kind of legal interpretation from someone qualified to make that decision. Because the truth is, if the court agrees that it's a valid claim, then you're kind of stuck with that, and you may end up being stuck not just with accepting the fact that you have to, indulge this accommodation. You might not have to pay attorney fees and court costs, and that's never good. This is a preventable issue, but you got to know before you're called on it, is this a reasonable accommodation or not? Just because I don't feel like doing it or feel like allowing it doesn't mean I may not be required to because of its reasonability. Number 3, Dawn McNary asks, can you limit animals to a set number, regardless of the status? I've seen this offered as a solution of having too many ESA and pets at the same property, but have a feeling this would not fly legally. But don't have facts to support this feeling. Can you address? Again, you can always limit pets. If you want to say 5 pets max, 2 pets max, 0 pets max, absolutely, you can always limit pets. When it comes to emotional support animals or assistance animals, that's where things get trickier. What if somebody comes with a letter that says they have 4 emotional support German Shepherds that they need in their 1-bedroom apartment? Whew, that's a lot of German Shepherds for one person in a 1-bedroom apartment. So the question is it reasonable? And the answer is maybe. You have every option to question it, to confirm it, to verify the validity of whatever documentation they provide to you. Certainly you should question it. But if after verification it appears to be 100% valid, and whatever medical professional that agreed to it did it based on the facts of that particular individual, I mean, there's a possibility that it makes sense for that individual to require that accommodation for their condition. Would I say that applies universally? Probably not. And could you potentially challenge something like that in court. Yes, but you run the risk that you are turned away and the judge says, look, they meet all of the standards for these assistance animals. And because of that, I'm not going to deny them their use. You must indulge this reasonable accommodation. And again, it might be reasonable based on the specific nature of this individual's condition and whatever service those animals supply to this individual. James, hey, says hello. Hello, James. Good to see you. All right. Lisa Martin Alvarez says, I would love a cheat sheet when it comes to service animals. Well, so when it comes to the state of Texas, there is some information out there that is supplied by the Texas government. I'll put a link in the description of this video. I don't know if I can, I don't think I can do it right now, but I'll definitely put a link to that document. It's available online, gives a lot of helpful information. It defines terms and gives examples of what can and cannot apply in these situations. So I'll be happy, Lisa, to offer that as a guide. And then hopefully that's helpful to you in the future. Don McNary jumps back in and asks, why, when advertising rentals, does no smoking work, but if you put no smoking, no vaping, and the AI ad checkers bounce and ad for discriminatory practices against a group of people, it is the no vape triggering the response. I've tried all different variations. Now I'm curious from a legal perspective. Well, honestly, I don't know where you're posting this and who is giving you this restriction. This may be limited to the company that you're using to post this. I'm not sure who you're using and on what basis they're referring to this as a discriminatory practice. It could be that certain vaping is not purely recreational. And again, if that's the case, if it's medicinal, for example, perhaps you couldn't restrict it. But as far as posting it and it being absolutely, an issue of discrimination, I just don't personally see that as, generally speaking, applicable. This might be restricted to what you're doing. And honestly, this is the first time I've ever heard this. If any of you have encountered this, I wouldn't mind hearing from you what your experience has been, but this might be restricted to whatever platform you're presently posting advertisements on. So, Shayna Griffin Brumley asks, are there only certain animals that can be ESA, parrot, donkey? Where and how can we draw the line? What is the best way to verify that someone has an ESA that won't get me in trouble? Can you still enforce rules on an ESA like you would rather only animal allowed to live in the house, such as noise violations, breed, weight restrictions of animals allowed, proof of shot records, etc.? So let's start with the last part. Can you require proof of vaccination, rabies shots, that sort of thing? Yes, I don't think that's unreasonable because, in the end, they're still animals, and it would be reasonable to require that if they're going to have an animal, like a dog or a cat, that they are properly vaccinated and you can protect yourself and others from the threat of rabies. So that's not unreasonable. These other restrictions are probably going to be seen as unreasonable. No, you can't just say, except for the exotic animals, you can't say you're not allowed to have any of these kinds of animals. Like I said at the beginning of this talk, when it comes to seeing eye animals, dogs and miniature horses, I'm not sure I've ever seen a seeing eye miniature horse, but the law says specifically dogs or miniature horses, that's it. That's all you can have for a seeing eye animal. For all these emotional support animals or other assistance animals, as long as some licensed medical professional has diagnosed an individual or is treating an individual and vouches for the need for a particular animal to serve as this assistance. I mean, that's the bar. It's not a super high bar, but you do need a licensed medical professional to step in and make that call. And if that call is made, it is very unlikely that you'll be able to put any of these kinds of restrictions, other than something reasonable having to do with vaccinations. I wouldn't advise putting any additional restrictions on the kind of animal, the breed, the size, the type, or the quantity, which unfortunately happens too. Again, 4 German Shepherds sounds like a lot to me, but again, it might survive scrutiny. So Lisa Tomberlin Copeland asks, tenants have 2 large German Shepherds, but have denied entry if they are not home as pets are not crated. How do we enter? Lee says we have the right to enter. Oh, and they just went month to month. We are showing the house. We asked for inspection within 15 days of going month to month, but no communication. Well, if this is in Texas, and I don't know that it is or isn't, these are people that probably have to go. You only need to send a 30-day notice of termination unless your lease requires something more. I would send that notice ASAP and then get them moving, because they're not going to help you. And while you can send notice, for example, saying, we plan to do an inspection. It is now Wednesday. I'd like to be there on Saturday. Please make sure that any animals are restrained. You show up and you immediately hear roof, 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 right at the door. It's clear that these animals are not restrained in any way. They are not. Look at what your lease says. What does your pet addendum say with regard to your right to enter and the duty of the tenant? I mean, sure, you can issue notices to vacate. You can issue notices of default for them failing to properly secure the animals. But your best bet, now that they're month to month, send that 30-day notice and just be done with them. They're not going to respect your rights, and so you got to move on. If they're still around after 30 days, issue that notice to vacate and then proceed to eviction if they're just going to be stubborn about it. Okay. Kat Vin, we are on question number 8. I want to remind you, if you have any questions you want to add to the live chat, go ahead and add those in just a bit. I'm going to get to this last question and then open it up to anybody who's got a question or is hanging on, waiting for an opportunity to ask. I suggest you add that now. Otherwise, here's the last one. So this is unrelated to the post. So he no longer calls animals pets. He says, today I reached out to HUD to get clarification on those who are exempt from the FHA rules due to own fewer than 4 properties, self-managed. I emailed and left a voicemail from a disabled tenant perspective, not a landlord perspective. I asked if exempt landlords advertise on Zillow. Are they no longer exempt? Looking forward to their answers. Zillow terms state they are not brokers or property managers. Although Zillow does have licensed agents in most states, that is only for real estate sales, and they are not involved with rentals. FHA states landlords who are exempt from the FHA laws cannot be discriminatory in advertising, but they still have the right to rent to who they choose. I do not condone discrimination. This is why I treat all applicants the same in regards to animals. Every American can claim a disability. Every ache, pain, personality trait, mental problem, stress, phobia. Most addictions are now disabilities. Anyone can claim PTSD. So if almost all Americans have a disability, the disabled are no longer minorities. People with disabilities who cannot tolerate the smell of urine and wet dog should have the same rights as those that claim their dogs as medical equipment. Many laws are vague. An attorney could argue these vague laws one way or another. until they rewrite with more clarity or expand the FHA laws concerning, quote, canine medical equipment. I will continue to exercise my legal right to treat all applicants equal in regards to animals. As mentioned earlier, yes, it is 100% true. There are exceptions to the Fair Housing Act. If you own fewer than 4 units, let's say you own 3, but this also includes selling units. So if during a given year you owned 6 and you sold off 3, and now you have fewer than 4, well, those first 3 count because you sold 3 and then leased 3. That's 4 or more units, either leased or sold. So again, that's something for you to consider, especially if part of your business is you buy and sell. So you do a little buy and hold, you lease some properties, but you do buy and sell, and occasionally throughout the year you also sell properties. That makes you subject to the Fair Housing Act because it's either or a combination of houses that you sell or houses that you lease in a given year. So that's 4, right? Once you hit that 4 threshold, you're subject to. Also, if you use a broker. And so what, and James writes, there are a lot of gray areas in the laws, unfortunately. And that's true. And then the laws change, right? And they can be modified to broaden definitions or narrow definitions. That also occurs. The other issue then is, you could still get sued. And so although you have an exemption, you're going to be forced to defend yourself in court against that claim. So let's say you lease to an individual or you deny 10 individuals access to any of your properties, and then each of those individuals sues you independently over the course of the next 2 years. They sue you because you discriminated against them because of their disability. And the next one sues you because you discriminated against them because of their disability, and again, and again, and again, and again. Now, I'm not going to tell you that that's common. It's not. But if it does happen and you have to pay every single time or lose time and effort going to the court and dealing with a tenant who is suing you for something you're exempt from, and you show the court every time, I'm exempt, I'm exempt, I'm exempt, I'm exempt, you run the following risks. Number one, there's the cost. That's absolute. It's going to cost you time, money, or just stress and frustration having to deal with this every time, even if you've got a valid defense. But 2, there is the risk that for whatever reason, the court decides, no, I don't believe you are exempt because of this, this, or this, or just because they're not feeling it. If a court determines you are not exempt from the Fair Housing Act, they might hold you to its standards. And by denying them and discriminating against someone with a disability, you might be called to pay a ton of money to somebody on that basis. Now, of course, you could appeal, but guess what that is? More time, more money, more cost, more frustration. So what I tend to recommend, except for those people who have one home and they're never going to ever have more than one rent house, if you got 2 or 3 and you're looking potentially to expand, just start following the FHA. Just start following, and when you get people who have assistance animals, deal with them the way you would anybody who's got animals. If anyone brings animals onto the property, you can say, look, I don't allow pets, but if you've got a valid assistance animal, believe me, I'm going to be on the property more, and landlords should be on the property more as it is, but you're going to be on the property more, and any damage that animal causes to the property. Now you're not talking about discrimination against the animal. You're talking about discrimination against the practice of property destruction, which is perfectly allowed. You can discriminate against people who destroy property. And so they get a notice of default, they get the bill to repair, and if they don't pay or they repeatedly damage the property because they're unable to control their animal, even if they can have that animal there because it is a service animal, They're not allowed carte blanche when it comes to destruction of your property. So I would say, get used to the idea that eventually the FHA is going to apply to you, or that eventually someone's going to call you on it and it's going to end up costing you more money than it is worth. But whenever somebody does come in with assistance animals, you hold them to their obligations. Number one, you make sure they can confirm and verify that they have a valid assistance animal. And then number two, they can keep that animal under control. And the moment they cause damage to your property, you call them on it. You issue a notice of default, you repair the issue, you issue a bill to the tenant, and their failure to pay means they got to go. Again, that's a different claim. You're not discriminating against their emotional support animal. You're discriminating against their destruction of your property. Or really, you're calling them on their breach. No one's allowed to destroy the property, whether they do it with an assistance animal or with a hammer. It doesn't matter. Destruction of property means you are harmed and you are due compensation for that. And they are responsible for it because it comes not from normal use, not from ordinary wear and tear. It comes from their animal. And if they can't control the animal, they got to go. But you have to issue written notice and you have to stay on top of it. You can't sit idly by, just like you can't with, tenants who have no pets. You can't just assume they're going to take care of the property as well as you would. You need to be on the property, and then you need to call them on destruction of property. If they bring harm to your property in excess of normal use, in excess of ordinary wear and tear, you got to call them on it, notice, you got to repair it, you got to give them a bill, and you got to hold them to that payment. And you're going to want to do it early in the process. You don't want to wait till the end because it's much harder to enforce these costs once they're gone than when they're there and plan to stay there for months and months and months. So in a nutshell, I understand, yes, you do have a defense, and it is a valid defense if you are subject to one of these exemptions. The problem with it is if you're right on that razor's edge, if you're right on the line, I don't know that it's a good strategy to live right there on the razor's edge. I would just commit and say, you know what, I'm just gonna act as though I am subject to it at all times, and I'm gonna follow the law, and I'm gonna enforce good property maintenance with my properties. And if I got somebody who's abusing that, I'm gonna call them on it. And if they won't pay what's owed and won't keep their dogs or cats or baby goats under submission, then they gotta go. So I hope this clears up some of these misconceptions. I hope this helps you whenever you're figuring out what to do when it comes to pets and non-pets. It can be a confusing topic. I'm gonna go and add that file for those of you who are waiting on it. I'm gonna add it to the description of this video so that you can access it. It's a government file that helps me and helps a lot of my clients just to kind of take a look at how does the government already define terms like assistance animal, terms like service animal, what kinds of things do and do not qualify in terms of a medical professional, or what kinds of things can I ask for and what kinds of things should I stay away from. I think this document is going to be very helpful. Again, take a look for it in the description, and I hope that you find that helpful. I got one question that just popped up from James. Is it okay to limit occupancy to 2 people per bedroom? Maybe. So think about mom, dad, and a baby. And so you can discriminate against families or family units. Excuse me. And so generally speaking, your jurisdiction is going to have a rule about occupancy. I think here in Harris County or in Texas even throughout, the limit is it 3 people per bedroom? I can't remember, but it's got to be a reasonable. It's got to be a reasonable thing. It's also going to depend on the square footage and whether it makes sense to limit it to just 2. But excuse me. I would check with your local jurisdiction and see what it already says about those limits. You may find that the numbers are actually quite big, and so you don't want to be guilty of discriminating against families or people with kids, that sort of thing. And so just be conscious of these potential claims that could come out there, limiting your unit for specific kinds of people. Again, kind of invites that claim that you're discriminating against family types. Doug Scala writes, can I use an application of funds clause even if it's not stated in the lease? It's going to be harder for you to justify that to the court. Can you apply it that way? Yes. And so what I would recommend that you do is, if you don't have an application of funds clause in your lease, that you at least have a ledger that reflects how funds were applied and in what order they were applied. So if you're applying funds in based on the first calculated fees or the latest fees posted, then naturally it's going to operate as an application of funds clause. But if you don't have it and you try to make an application of funds clause argument in a court where the facts are pretty narrow, you might get some blowback from the court. So always do whatever you can to operate with an application of funds clause. If you don't have it and you'd like to utilize that strategy, keep a clean ledger where you show how funds are applied. And I believe that could potentially save the day. Yeah. Okay, guys. Well, it's been great. I wish you all the best. I will be back next week, assuming that I don't have a hearing that pops up. That happens from time to time. But if you join me next week, April the 23rd, our topic will be, how can I prevent squatters from costing me thousands? We're talking all about squatters next time. But until then, landlords, I wish you the best and happy